Good afternoon. My name is Alina Shaltsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you and tell you about what to do if you filed your adjustment of status application and it was denied because you missed your interview. In most scenarios, if you're filing for adjustment of status based on marriage, let's say to a US citizen, you're going to receive a notice inviting you for an interview with your spouse. And this is a necessary step that you cannot avoid. You will have to appear for the interview where an immigration officer is going to question you and your spouse about the different details of your marriage and your relationship, and also about your eligibility to receive green card or status of lawful permanent resident status in the United States. But quite often people come to me and they say, well, I filed my case, but it was denied because I didn't come for the interview. And usually there are two reasons for that. One reason would be the person did not receive a notice for the interview. Even though the person was waiting for the notice, maybe he or she checked online and saw that the interview was scheduled and the notice was mailed but never got it. Or another reason usually is that the person contacted USCIS and stated that, I need to reschedule my interview, but nevertheless received a denial for no-show. As a rule, in that denial decision, you're going to receive instructions that you can appeal or file motion to reopen the case. So you're going to have at least two options in this situation. You can file a motion to reopen your case, or you can simply refile your case in most situations. This video is not a legal advice, of course, because a person has to consult with an attorney in most cases, or in all cases when we talk about legal issues. But it's possible, usually, and it's sometimes better to refile the case if you can. When can you refile the case instead of trying to file a motion to reopen? When your unlawful presence time is not an issue. For example, when you are married to a US citizen, okay, and unlawful presence of any that you may accumulate or will accumulate in the United States is going to be automatically forgiven to you. Then, rather than dealing with motions to reopen, which very often is denied, by the way, because the government is going to produce records showing that they did mail you the notice most of the times, even though you never received it, or they're going to say that your reason for asking to postpone the interview is not sufficient, so the motion to reopen will be denied. In most cases, you can simply resubmit the package, okay? Price-wise, by the way, it's also probably going to be better for you, because when you file a motion to reopen, there is a filing fee for it, and you'll need to file a motion to reopen for two forms, I-130 and I-245I, if I-130 was not granted, right? And for refiling the case, the current fee is $1,760. And the time-wise, how it works, also refiling the case may be better than filing motion to reopen. When would you want to file a motion to reopen rather than refile the case? When your adjustment of status application based on employment, that's a totally different situation. Usually, to adjust based on employment, you have to be in lawful status prior to filing for adjustment of status. So every day when you are out of status, counts against your ability to adjust status in the United States, because you may have a window in your lawful status up to 180 days for adjustment cases based on employment. In this particular situation, you may be better off filing motion to reopen. because if that motion will be granted, it's going to basically get you back to the point of the first time when you refiled the case, so you may not have a hole in your adjustment of status, in your lawful status for adjustment of status purposes. It's a little bit confusing, of course, maybe I'm not very clear, but basically the rule of thumb is this: if you're filing adjustment of status based on marriage, usually you would want to refile the case. If based on employment, you would seek motion to reopen if possible. Okay, so this would be your options. So if you got the denial based on no show, usually it's not a problem. All right, you can refile. It can be easily amended. And you can read more about various issues in immigration and what to do if you receive a denial or request for more evidence or a notice of intent to deny on our website, www.sheltsova.com. Thank you.